I'm very happy to introduce our colleague, Dr. Božena Bulum. She will speak about the supply of technical nautical services in the Croatian public ports, with particular reference to the issue of self-handling of these services by carriers. Dr. Bulum is my colleague. She's a scientific advisor at the Adriatic Institute of the Croatian Academy of Sciences and Arts. She has a bar exam and a PhD, and she's an author of a book and a number of academic publications. Her area of research interests includes, in particular, EU transport law and maritime transport law.
My topic today is, as Adriana already said, supply of technical nautical services in the Croatian public ports, with particular reference to the issue of self-handling of these services by the carriers. This paper is a result of research under the research project Challenges in the Legal Regulation of Seaports, considering application of the European Union law and national legal tradition. So Petra already spoke about pilotage services, and my theme is technical nautical services in general. So these services are services auxiliary to navigation provided to vessels in ports for reasons of safety, security, and environmental protection. Italian scholars, Professors Sergio Carbone and Francesco Munari, created the term technical nautical services, and EU Commission used this notion in some of its instruments creating EU port policy. There are mainly three technical nautical services. Pilotage, which means the guidance service of a waterborne vessel by a pilot or pilotage station in order to allow for safe entry or exit of the waterborne vessel in the water access to port or safe navigation within a port, as we know. And also towage means the assistance given to a waterborne vessel by means of a tug in order to allow for a safe entry or exit of the port or safe navigation within a port by providing assistance to the maneuvering of the vessel. Also, mooring means the berthing and unberthing services, including shifting along the quayside that are required for the safe operation of a waterborne vessel in the port or in a waterway access to the port. The special features of technical nautical services compared to other port services are in particular that technical nautical services are rendered in favor of vessels calling in port, and other services offered in ports are related to ship cargo or passengers handling. So letter services mainly have a commercial nature and can be organized under competitive patterns. On the other hand, technical nautical services are focused on the safety matters, offered and organized mainly for non-economic reasons, safety, security, and environmental protection. And what is important is that their main feature of technical nautical service is availability of services. This means that those services must be provided 24 hours a day, 365 days a year. It is so-called provision around the clock, around the year. And for that reason, those services are subject to specific rules in respect of their organization, supply, and market access. As regards legal regime of technical nautical services under EU law, these services that are characterized by the need for availability to all their users at any time and at an affordable price are universal services. Universal services belong to services of general interest or public services. Technical nautical services are offered as universal service when following conditions are fulfilled. These conditions are when supplies of service is when services supplies to all the users that's requested. So user can come with any vessels, any crew, at any meteo marine conditions. Also, there are predetermined rules regarding the quality and supply procedures, and tariffs are fixed in advance. Their level is affordable, and also there are no interruptions in the provision of services. Technical nautical services are services of general economic interests because their providers make profit from the provision of those services. Services of general economic interests in EU law are defined as economic activities which deliver outcomes in the overall public goods that would not be supplied by the market without public intervention. So technical nautical services are also examples of market failure. For that reason, member states may intervene on the market of these services and organize them according to the models that deviate from the competitive ones in order to provide general interests and to provide universal provision of the services. And that includes monopoly situations in ports, mandatory nature of the service or exclusion of self-handling of these services, or provision of service may require professional qualifications for workers providing those services. And these are issues we are discussing later in this presentation. So let's say something also about EU law on general economic, on services of general economic interests, which covers also the technical nautical services as kind of those services. Very important is Protocol 26 of the Treaty on Services of General Interest. According to that protocol, the shared values of the Union in respect of services of general economic interest include, in particular, wide discretion of member states in providing, commissioning, and organizing services of general interests, and a high level of quality, safety, and affordability, equal treatment, and the promotion of universal services, and also of user rights. In order to accomplish that, according to Article 106 of the treaty, undertakings entrusted with the operational services of general economic interest shall be subject to the rules contained in the treaties, in particular to the rules on competition, but so far as the application of such rules does not obstruct the performance of the particular tasks assigned to them. So member states have a wide discretion in defining and organizing the provision of services of general economic interests, including technical nautical services. But as we see by the case law on services of general economic interest, those discretionary powers are not unlimited. Member states may just a second, something is not working. Member states may use that. Member states use that discretionary power to define services of general economic interest, and that cannot be exercised arbitrarily for the sole purpose of removing of a particular sector from the application of the competition rules. Also, EU institutions may question the definition of services of general economic interest only in the event of a manifest error. So let's move on to the EU case law applicable to technical nautical services. That case law confirmed the already mentioned case law of the services of general economic interests. So in the landmark judgment in the mooring sector brought by the Court of Justice of the European Union in 1996, the court approved monopolies that existed in ports of Genoa and La Spezia. And also the court confirmed that mooring services are services of general economic interest. Therefore, member states may organize their provision according to the models deviating from the competitive one. And also, port users have to pay the price supplement to to finance extra costs that providers of mooring services had because they provide public or universal mooring services. Also, according to the TAKES law, member states may introduce mandatory nature of technical nautical service and exclude self-handling of these services in order to safeguard the general interests of safety, security, etc. And also, member states may decide that the provision of technical nautical services may require professional qualifications for workers providing these services. So these are very important judgments brought by the Court of Justice of the European Union regarding the technical nautical services, especially when we consider that those services and their provision and self-handling is not regulated, as we will see, with the European Union secondary law. And now, what about the self-handling? Self-handling is a situation when port user provides for itself one or more categories of port services. And self-handling on technical nautical services was very disputable issue. It is disputable until today. And their regulation under EU and under Croatian law is also very disputable. So let's see. European Commission instruments on port policy regulated self-handling of all port services, including technical nautical services. So a proposal from 2001 for a directive on market access to port services was met with strong opposition from dock workers' unions, and it was rejected by the parliament because dock workers were afraid that in case when carriers self-handled the port activities, including technical nautical port services, they will lose their jobs. So also in 2004, new proposal for a directive on market access to port services was made by the Commission, but there were strong protests of dock workers and their unions. So in 2006, that proposal was withdrawn by the Commission. So what was disputable? The most disputable thing was the self-handling of port services. With proposal 1, self-handling of technical nautical services was also allowed. And it was allowed only for the crew members or seafarers, but by the proposal 2, it was allowed only also to the land-based personnel of the carrier. So among scholars, it was debated for a long time, and that this was not good solution, because the receiver of the technical nautical service is a vessel, and port workers are less skilled than seafarers for the provision of those services which are provided to a vessel. So legal regime of technical nautical services under regulation from 2070, so-called EU seaports regulations. It is very interesting that that regulation defines port technical nautical services, port pilotage, towage, and mooring, but it does not use the term technical nautical services. Pilotage is excluded from the application of the provision on market access, Chapter 2 of this EU seaports regulation, in order to provide member states discretion to organize the provision of pilotage in a way that is suitable for a particular port and that safeguards the general interests of safety, security, and environmental protection. Also, regulation encourages member states to use the pilot exemption certificates. It is, in fact, exemption from the compulsory pilotage that constitutes self-handling. And the aim of this provision is to stimulate short sea shipping. Also, according to the Article 7 of the EU Seaports Regulation, member state may decide to impose public service obligations on providers of port services in order to ensure the availability of port service to all port users without interruption, day and night, around the year. So it is very important for the provision of technical nautical services, the affordability of the service for certain categories of users, the safety, security, or environmental sustainability of port operations, etc. So in a way, these services are also regulated by the regulation, but what is important, self-handling of port services, including self-handling of technical nautical services, remained outside the scope of the regulation. So EU institutions decided to leave for member states the decision regarding the self-handling of port services, including self-handling of technical nautical services. It is mainly for political reasons, because member states couldn't agree about these issues, and because two proposals from 2001 and 2004, as we mentioned before, were rejected or withdrawn because of the self-handling issue, because of the protest of the port workers. So it is a political compromise, I would say, which is not so good, in my opinion. As regards Croatian regime of technical nautical port services, it should be mentioned that pursuant to Article 66 of the Maritime Domain and Seaports Act, all port services in ports open for public transport, public seaports, may be provided only by private operators on the basis of a granted concession. Croatia, therefore, has chosen the landlord port management model for its ports. This means that port authorities do not provide port services themselves, but perform the role of a landlord, which is responsible for managing the real estate within the port area. As a consequence, technical nautical port services in Croatian public ports should be transferred to private sector. According to the relevant domestic regulation, we may conclude that port authorities should have no role in providing any technical nautical port services. But we also have a regulation on self-handling of technical nautical service in Croatian port sector. Self-handling is regulated, as Petra was already mentioned, only for pilotage services. According to Ordinance on Maritime Pilotage, in addition to the prescribed technical characteristics of the ship, the master must know the local conditions of a particular port, which is checked by theoretical and practical examinations. And as regards mooring, some carriers in Croatian ports handled mooring services themselves for vessels carrying maritime coastal line traffic in Croatia for decades. But, however, recently port authorities have started to provide mooring services and have employed additional personnel, port workers, but they provide mooring services only during the working hours of the port authority, from 8 a.m. to 16 p.m. And they prohibit self-handling of these services to the carriers. This causes resistance from the carriers, who employ additional seamen for the provision of the mooring services. So this dispute is still going on, and we are asking ourselves how to settle it. Applicable EU secondary legislation, EU support regulation, does not regulate the issue of self-handling of port services. So we must look at the EU case law on technical nautical services and services of general economic interest. According to the EU case law, technical nautical services are provided to vessels in ports for reason of protecting general interest of safety, security, and environmental protection as we said many times. And as the recipient of the service is a ship, port workers are less qualified for the provision of technical nautical services than seafarers. And in this case, in Croatian public ports, personnel employed by the port authorities are not seafarers. Also, according to the EU case law, technical nautical services should be provided without interruptions. As we said before, round the clock, round the year provision of the service is necessary. Port workers employed by Croatian port authorities provide mooring services only during the working hours of the port authority. So we cannot talk about the round the clock, round the year provision. Also, according to EU case law, discretionary powers of public bodies in the member states to define services of general economic interest and organize their provision should be used to safeguard general interest of safety, etc. In our opinion, in Croatian public seaports, this is not the case. Port authorities use their discretionary powers and forbid self-handling of mooring services to make profit from the provision of these services, so we may talk about misuse of discretionary powers of these bodies. Also, according to the relevant domestic legislation, port authorities should have no role in providing any port services, including technical nautical services, as we also mentioned above. The recent practice of port authorities is contrary to the national legislation. And self-handling on mooring services in Croatian public seaports by the carriers does not put in danger general interests of safety, security, and environmental protection. The argument for that is that some carriers provide the mooring services for decades and no accidents ever happened. And in our opinion, when creating legal rules on self-handling of mooring services in Croatian public seaports, we must look at best practices in the Croatian port sector. So there are many examples of good practice of provision of mooring services by the carriers. So there is no reason to forbid that practice when it works well. It is our opinion. So thank you for your attention.